Welcome to Compass Media. It is Tuesday, the 7th of March 2023. Last night, RTE Investigates revealed that psychologists operating in Ireland do not have to be registered. In effect, anybody can set themselves up as a psychologist. The programme was presented by Barry O'Kelly, who literally showed how easy it was to put a brass plate on a door and buy his certification online. He then went on to interview a number of mothers of children with special needs. It was possible to interview these mothers because they are not bound by the in-camera rule that operates in the family law courts, unlike the mothers whose children have been taken by Tusla in the secret family law courts governed by the in-camera rule. The Alliance of Birth Mothers Campaigning for Justice has been aware for a considerable number of years that many of these so-called court experts have no proper qualifications. It is a matter that the Alliance raised with officers from the Office of the Children's Ombudsman last September when they had a meeting with them. In response to a request for an update on the outcomes of the meeting that we had with the Office of the Children's Ombudsman in September, the Alliance of Birth Mothers Campaigning for Justice received an email on the 30th of January last, which says, due to workload constraints as well as the OCO's priorities as outlined in our strategic plan, we're not in a position to do a standalone piece of work on the issue you raised. The Alliance of Birth Mothers Campaigning for Justice currently has a petition before the Oireachtas Joint Committee on Petitions, seeking to give extra powers to HICWA to sanction Tusla when they're found to be non-compliant during inspections. In response to our submission to the Petitions Committee, the Minister for Children, Roderick O'Gorman, wrote to the committee stating that people with complaints about Tusla can submit them to the Office of the Children's Ombudsman, and that social workers and other professionals are all accredited by Curo. The Petitions Committee called on the Alliance of Birth Mothers Campaigning for Justice to respond to the letter sent to them by Minister O'Gorman. In reply, the Alliance said, Curo cannot interfere with evidence given in court proceedings or overturn the decision of the court. Complaints to Curo should therefore not be used for second-guessing either a registrant's professional judgment expressed to a court in evidence or a decision made by the court. In the letter, we went on to say, in effect, psychologists currently employed by Tusla to write up various reports for the family law courts are not regulated. This is an issue which has been raised in the Dáil on a number of occasions in recent months. The birth mothers we represent have no access to justice when these reports contain inaccurate information. The Alliance of Birth Mothers Campaigning for Justice ended their letter by saying, in conclusion, the Alliance of Birth Mothers Campaigning for Justice petition to amend the Child Care Act to provide HICWA with the necessary powers to sanction Tusla, the Child and Family Agency, when it fails to meet its statutory obligations. Mothers in the Alliance of Birth Mothers Campaigning for Justice, when sharing their experience with each other, it became abundantly clear that many of the court experts operating in the family law courts are merely copying and pasting. One particular court expert has a favourite phrase: this mother is so intellectually incapacitated that she can scarcely plug in a kettle. The reports submitted to the family law courts come with recommendations which are generally upheld by the judges. And as a result, many mothers have lost their children into state care as a result of the reports and recommendations made by these experts, who are really charlatans with no accreditation whatsoever. Deputy Bernard Durkin has, since last September, made several attempts to raise this issue in the Dáil. Mothers who have reported their children being sexually abused have had their children removed from them on the recommendations of a number of different experts that are operating in the courts who have no accreditation whatsoever. I'm going to leave you now with a montage of the numerous attempts by Deputy Bernard Durkin to raise this issue in the Dáil since last September. Thank you for watching, and please share out this video.
The situation is simply this, that I know this family well, and obviously with the procedure, family law procedure, both sides have an opportunity to make their case and have it challenged. In her particular case, she was greeted with a child psychology report, which was accepted without challenge, and she was never given an opportunity to challenge it. Now, you and I have been in courts many times up and down this country, and in our neighbouring country as well. I have never seen a case where a situation wasn't challengeable by the opposite side. But it wasn't. And the upshot of everything was that the children were taken away from the mother and handed over to the father, who was absent from the house for prior reasons. And since last May, that woman, that mother, has not had an opportunity of meeting with her children since, one of whom tried to run away from school, and who are really distressed and unhappy at the present time. Now, the mother of the children is always regarded as the primary carer, and to take the children away from its natural mother is the most appalling thing that can be done to any woman, because it challenges her right to be regarded as a good mother. This woman, she rejects vehemently all the charges that were made against her. But most of all, in leading up to a final decision, she's been prevented from talking to her children on the basis that she might turn them against their father. Obliquely, she was threatened if she raised it with any public body, including Tusla or public representatives. Raised a couple of times already in this House over the last few weeks. That's the increasing reliance in the family law courts of very subjective Section 47 reports, resulting in the removal of children from the custody of their mother in appalling circumstances, where they were ordered by the court to enter the classroom. I know.
Deputy, that is a specific case you're referring to, and you're making allegations about subjective reports, where now there is a division in relation to this House and the courts. So I would ask you now just to reflect on what you're saying. You can proceed. Well,
if you hear me out, you might understand why I'm saying it. Why I'm saying it, resulting in the removal of the children in that callous fashion, and placing them in the custody of their other parent, who was previously.
Deputy, you're out of order.
I'm sorry, Cancorla. I'm sorry. There's only one move left for me now. I can only do one thing now.
Deputy, I'm standing up now, so that's
all right. I will put down a motion in the House asking for the removal of the offending officer of the court from the bench.
Deputy, resume your seat. I do so reluctantly. Resume your seat. No.
I'm sorry.
Deputy, the time is running. You're out of time. You're out of order. This is my. Resume your seat. Deputy, resume your seat. Resume your seat.
The issue is already in the public.
Okay, I'm going to have to abandon the Dáil if you don't resume your seat. Well, can you please? No. You're ignoring the Cancorla's order. It's a very serious. Okay, I'm going to. That's it. I am going to now put an end to promised legislation.
And that is the use of Section 47 reports, and the degree to which the courts take into account the Section 47, which I have previously relayed to the Minister. And relayed to the House twice, in fact, in recent times, whereby a court messenger can, by virtue of his or her recommendation to the court, make it possible to take away the children from a mother who is, in order to ensure a particular outcome to a forthcoming case. That's really what it amounts to. And in cases that I have dealt with in recent times, the mothers have been separated from their children, have been subjected to appalling indifference and callousness by the system, whereby they are removed from their children removed from them callously, and put in a place of the determination of the court, but which in turn can predetermine the outcome of a family law case. Now, I recognise that the family law cases are held in camera as well. I think there's a case for removing the in-camera rule and let the air into the system to such an extent that everybody knows what to expect when they go. And incidentally, I'm not blaming judges or anything like that. I'm simply saying that these issues need to be dealt with. We need to deal with them in this House by way of legislation, and I hope that the Minister will introduce legislation in this regard. If I could go on for a very long time in relation to how we deal with these issues when they arise, I think it's important to bring them to the attention of the House and to the Minister, whatever the issues are, even though the House may say, well, this is a matter for the courts, you have to bring it right to the courts. That's not our function. That's not our function in this House. Our function in this House is to raise in the House something that appears to be going wrong and appears to be in need of attention. And if that is presumably on the basis that right is right and two wrongs don't make a right, presumably at some stage we get to recognise, as I do, that there were situations in this country in the past where issues were raised in the House and against the rule, as it were, with huge opposition, that ultimately ended up in major inquiries, serious inquiries, involving a whole lot of people. It would have been far better to have dealt with them originally. And I finish again by simply drawing to section 47. Minister, it needs to be dealt with, and it needs to be dealt with soon, because there will be a tragedy. The level of emotion, trauma, and the coldness of what surrounds a mother when she is told that she doesn't matter in this business, or that if she does matter only in a way decided by somebody else. And if the activities of Mr. Sheehan, Jim Sheehan, in the courts are allowed to continue, there will be serious consequences. In the last couple of days, I received notice from Tusla to the effect that I would not be allowed to attend a case conference because there was an objection. And that was a surprise, because my only interest in it was to ensure that the rights of the child were preserved and that the rights of the parent, all parents, were preserved. Over the years, here like yourself, I attended the Royal Court of Justice over the years, and most other courts, including the family law courts, over the years, to give evidence on behalf of what I felt were deserving cases. And I was always welcomed. And I didn't lose in my intervention either. So the position now remains, I think, for Tusla to exert itself in such a way as to ensure that without doubt we are absolutely assured of its intention to preserve in all circumstances and assert the rights of the child in these particular circumstances. But the problem is there are a number of children and their parents who are already victims of the system, where mothers are even prevented from meeting with the children and are subject to the most appalling hardship and disregard in terms of the children's rights, the children's entitlements, and their own rights, the mother's rights. And they have very important maternal rights. And at this moment, these rights are being abused. And I have seen evidence to the effect that Tusla cannot decide what they should do because they're prevented from doing so, following their own conscience and their own responsibilities by the in-camera rule. I wish to raise again the issue of the continued persecution and prosecution of Irish mothers and their children in the family law courts, the degree to which an alien resolution is attempted to be imposed on the law here, for which there's no basis, and the urgent need for an inquiry into its effects on women and children, and the need to make an interim arrangement whereby the persecution and prosecution is discontinued, resulting in many cases in arrest and imprisonment.
Thank you, Deputy. You've raised this matter, and I've repeatedly pointed out to you, I'm going to let the Taoiseach come in, I've repeatedly pointed out to you the separation of powers, and you're raising serious allegations that cross the border. I'm not taking issue that you might be raising a serious issue, but the manner in which you're raising it, I have to once again draw your attention to the separation of powers. Taoiseach.
Over the past 6 months, I repeatedly raised the question on the plight of a large number of women who, throughout the length and breadth of this country, who find themselves subjected to extraordinary abusive situations, whereby, in many cases, they are not allowed to meet or see their children except by telephone, where nothing appears to be happening as a matter of urgency, where something must happen as a matter of urgency. Otherwise, this House is actually turning its back on the women who are mothers who are being subject to this treatment. So I ask the Taoiseach or the Minister today what action is proposed. I have had brought to my attention in recent times the concern of a fairly considerable cohort of women who are mothers who find themselves in a situation that their children are removed from them, not because they were a bad mother or that they had a bad home, but for other reasons, and are the victims in terms of referral to the system, through the system, through numerous hearings, whereby they acknowledge that they will not have attention brought to their concerns that they have brought to the attention of the appropriate authorities, and that their children continue to be created as aliens from them. And that we don't seem to be able to come to grips with it. But I'm asking you, Minister, at this particular stage, to please recognise this problem exists, and that Tusla has an obligation to protect children. And the Children First legislation is there for that purpose, but it doesn't always apply. Taoiseach, I bring to the attention of the House the scandalous situation of the treatment of women who are mothers who are going through the family law courts, wherein their rights are being abolished virtually, where under the in-camera rule they're being subject to the kind of abuse that was used in prisoner of war camps in years gone by, and which is totally alien to the Irish Constitution, the Irish justice system, and in fact human rights. And I would ask that the present legislation, which is going through the other House, be expedited, and that in the interim the use of the so-called parental alienation theory be abandoned. Again, the issue of the disgraceful treatment of women and their children, and indeed some men, before the family law courts, who are consistently subject to extraordinary treatment with leaving only one outcome. But in view of the most recent information made available to my department, the situation has taken a different turn and much more serious. I have referred this information to the ministers, relevant ministers, Justice and Children, but it would appear to me now that at least a preliminary inquiry should be carried out to ascertain the full extent of what is happening before it reaches the serious consequences of a major national scandal.
Thank you, Deputy Durkin.
I'm not fully aware of the details behind the range of cases that might have given rise to the comments that you've made, but I will discuss this with the Minister for Justice and alert the Minister for Justice that you've raised this issue on the floor of the House and that you believe that there are serious matters of public interest that need to be reflected upon.